remember that line in the film Forrest Gump when the hero quotes his mother saying, "Life is like a box of chocolates. You never know which one you're going to get." Well, that applies to any talk entitled Miscellany, so we won't spoil it by telling you what it covers, but if you've had a peek at the slides, you've probably got a fairly good idea. But the first topic is that hardy perennial. When is someone an employee? You've probably frequently heard us talk about the need for mutuality of obligation for a relationship to amount to one of employer and employee. So in other words, the obligation on the employer to provide work and the employee to do that work. And that's an absolute key requirement. But it's not the only one, as the next case shows.
Okay, in Troutbeck and White, the company owned a farm which was bought as an investment. An oral agreement was reached with Mr. White that he and his partner would live in a flat on the premises, rent-free, and they would take care and manage the farm. The arrangement was later set out in a written agreement, which referred to itself as this employment agreement. It stated that the company agreed to employ the couple, who were to take care of the accommodation and grounds, and that on ceasing to be employed by the owner, they would vacate the accommodation. The couple also had to notify the owners of any maintenance that required expenditure before incurring any cost. The couple were paid a personal allowance, were entitled to 30 days paid holiday a year, and the agreement was terminable by 3 months' notice on either side. There were, however, no fixed hours of work, and the company had no day-to-day control over what Mr. White and his partner did, or indeed how they did it. The agreement specifically provided that the couple could take employment elsewhere, as long as doing so didn't diminish or restrict the performance of their work on the farm. And in fact, they both did have other jobs. The owners occasionally visited at holiday times, but otherwise just left them to it. The decision was made to sell the farm, and Mr. White and his partner were sent a letter which stated that their employment contract was being terminated. The couple claimed unfair dismissal, but the company denied that they were employees and asserted that the agreement was nothing more than a commercial contract.
Well, the tribunal placed a great deal of weight on the fact that the company had no day-to-day control over what Mr. White and his partner did at the farm, and so they concluded that they were workers but not employees. Well, the couple successfully appealed to the EAT, and the issue, according to the EAT, wasn't whether the individual exercises day-to-day control over their own work, but whether there's a sufficient degree, so a contractual right of control over them. The AT pointed out that there are many employees, including skilled professionals, who have a great deal of autonomy in the way that they carry out their work. And as the AT said, it does not follow that because an absentee master has entrusted day-to-day control to such retainers, he's divested himself of the contractual right to give instructions to them. It sounds like a line from 12 Years a Slave.
While we're on this subject, here's another case on when is someone an employee. When considering a person's employment status, the tribunal won't rely on what the contractual documentation says. It will look at all the circumstances to establish if, in practice, the contract terms reflect the reality of the situation. In Pulse Healthcare Limited and Carewatch Care Services, the claimants were held to be employed under contracts of employment, despite the fact that the contracts actually said the opposite, and the apparent absence of the obligation to provide work. The documentation included a 0 hours contract agreement. Now, a 0 hours contract is one where a person isn't contracted to work a set number of hours, and they're only paid for the number of hours that they actually work. While the employer does not guarantee any work, a common feature of these arrangements is that staff are expected to be on standby, so in practice they're unable to be employed elsewhere. The EAT upheld the tribunal's finding that the 0 hours contracts did not reflect the true agreement between the parties. The individuals were engaged to provide critical care to a single patient on a shift system around the clock, and in practice they had to be available throughout the shifts. The EAT considered it fanciful that such care would have been provided through reliance on ad hoc arrangements.
Well, according to the Office for National Statistics figures, 250,000 workers are on 0 hours contracts, which represents about 1% of the UK workforce. 0 hours contracts have received a lot of adverse media coverage recently amid concerns that employers are using them to abuse workers. In practice, 0 hours, like any other contract, have advantages and disadvantages for both sides. Those opposed to 0 hours contracts complain that they're unworkable for people with family and caring commitments, and that fluctuating earnings make it impossible to plan ahead, pay bills, and can also cause problems for those who are claiming benefits. Now, while there are clearly disadvantages to the system, this way of working does suit some people. In other words, those who are using the work as a stopgap whilst they're looking for something more permanent, or students during periods of leave. The appeal for employers is that 0 hours contracts are a cost-effective way of managing fluctuations in demand. So you effectively have a pool of workers available to whom you don't have to pay permanent salaries. 0 hours contracts also give rise to fewer employment obligations. In most situations, there's no mutuality of obligation, so that means the workers don't acquire the necessary employment status to gain the full range of employment protections, including especially the right not to be unfairly dismissed. They will still, however, be workers, and so have rights such as the right to holiday pay, national minimum wage, when they're actually working. So 0 hours contracts are not entirely obligation-free for employers. And in December, Business Secretary Vince Cable launched a consultation into the use of 0 hours contracts, and that's actually going to close tomorrow. And whilst he said that a complete ban is unlikely, he is aiming to crack down on the use of exclusivity clauses, which prevent workers working for anyone else, and also to tackle any abuse that relates to the national minimum wage.
And now for a subject dear to my heart, holiday, although not in this context. You may recall our telling you that the European Court had held that workers who are absent on long-term sick leave are entitled to continue to accrue the 4 weeks minimum holiday entitlement while they're off sick. And if that means that they cannot take their entitlement in the holiday year in question, they're allowed to carry the balance over into the next holiday year. You'll also remember that under EU law, full-time workers are entitled to 20 days paid holiday, including bank holidays, but under UK law, it's 28 days. The law was less clear as to whether this right to carry over applied to those extra 8 days, and this was the point that arose in Sued Enterprises Limited and Healy. Mr. Healy was entitled to his 28 days holiday. In July 2010, he suffered a stroke and was on sickness absence until he resigned in June 2011. His absence spanned across 2 leave years, which ran from January to December. Upon termination, he was not paid in lieu for the leave that he'd been unable to take during those 2 leave years due to his sickness, and he brought a claim for unlawful deduction of wages, and the tribunal upheld his claim. The tribunal didn't just limit this to the 4 weeks or 20 days provided for under the directive. The company appealed, arguing that the additional 8 days provided for under the UK working time regulations should have been excluded from the calculation, and the EAT has agreed. It decided that the European Court decision only allowed the basic 4 weeks or 20 days to be carried over, not the more generous 28 days contained in our own domestic regulations. So they were lost when the new leave year began and did not have to be paid when the employment ended.
Okay, still on the subject of holiday, in Podlasiak and Edinburgh Woolen Mill, an employment tribunal decided that it's not permissible for an employer to pay a token sum in lieu of holiday entitlement. Ms. Podlasiak was employed on a 0 hours contract, and that contract provided that on termination she'd be paid £1 in lieu of any untaken holiday. When she left her employment, she had 3 days accrued but untaken holiday leave owing to her, and if she'd taken that during her employment, she'd have been paid about £176 net of tax, but instead she got £1. Big money, but it was clearly important to her, so she brought a tribunal claim. And it's also important to some of you because you may well find that your contracts or handbook attempt to reduce the amount payable for accrued holiday when a person leaves. Now, the tribunal noted that under the working time regulations, a full-time worker is entitled to 28 days paid annual leave, and where some of that leave has not been taken at the termination date, they're entitled to a payment in lieu. The regulations state that this payment may be as provided for in a relevant agreement, or the amount the worker would normally be entitled to as paid leave. So on a literal reading of that wording, it was permissible for the contract to provide for a token payment of £1. But the European Court of Justice has previously decided that the amount paid should reflect what the person would have been paid had they actually taken the holiday. So this is what the tribunal decided in her case. The decision hasn't been appealed, so we're going to have to wait for another authoritative decision. For example, you sometimes see in contracts a provision which says that if a person's dismissed for gross misconduct, or if they don't give their full contractual notice, their holiday pay entitlement will be reduced to, say, the level of national minimum wage. And this decision suggests that this is challengeable, but for the moment we're not suggesting that you make any changes.
When we were preparing our notes for the next subject, whistleblowing, we came across a copy of the Daily Mail that a client had left behind. This included a report about Rachel Ashley, who was house mother at a public school in Oxfordshire. According to the newspaper report, she's claiming that she's been unfairly constructively dismissed and subjected to a detriment for blowing the whistle on pupils who are alleged to have beaten wild birds to death, skinned cats alive, and wrapped a younger pupil in duct tape before beating him with a belt. Sound absolutely delightful, don't they? She says that the headmaster said in response to her concerns, well, boys will be boys, sought to cover it all up and didn't take her concerns about her safety and that of other pupils seriously. Of course, all we know is what we read in the Daily Mail, so it's got to be true, isn't it? Whistleblowing covers all sorts of situations, some more obvious than others. So we need to introduce some legal terminology at this point. A qualifying disclosure is a disclosure of information that the worker reasonably believes shows that one or more of the following is either happening, has taken place, or is likely to happen in the future. And that's a criminal offence, the breach of a legal obligation, a miscarriage of justice, a danger to the health and safety of any individual, damage to the environment, or a deliberate attempt to conceal any of those things. Following a change in legislation last year, a second requirement has been added that the individual must reasonably believe that the disclosure is in the public interest. Now, we don't have any cases on this as yet, but it does raise lots of interesting arguments, which is wonderful for news for us. If someone complains about a health and safety issue which is taking place in their office and it only affects them and a couple of other people with whom they work, would that satisfy this new requirement of public interest? Well, we don't know. It's not that clear at the moment. Up to now, the breach of a legal obligation has included the breach of the individual's own employment contract, and it's that sort of case which was never intended to be covered by whistleblowing. So the requirement for there to be a public interest will probably prevent such claims, but time will tell.
Okay, and now for something completely different. In West London Mental Health, NHS Trust and Chabra, this case concerned the slightly unusual situation of an employee who was seeking an injunction to prevent the employer taking the most severe form of disciplinary action that was permitted under its procedures. Dr. Chabra was employed by the Trust as a consultant forensic psychiatrist at Broadmoor Hospital, and a member of the public made an allegation to the Trust that she'd breached patient confidentiality whilst travelling on a train. The complaint was that she discussed her work with a colleague and read patient notes in such a way that her place of work and confidential patient information were clearly identifiable to fellow passengers. Secretarial staff had also alleged that she dictated reports containing sensitive patient information while she was on public transport, and would often call her secretary on her journey to work, during which patient information would again be discussed. Well, Dr. Chabra was given a partial suspension, and the Trust appointed an external consultant forensic psychiatrist to investigate. They upheld the first two complaints And they concluded that given the nature of the working environment and the patients at Broadmoor, Dr. Chabra's conduct amounted to a serious breach of the General Medical Council guidelines on confidentiality. The report also raised a number of capability issues. Dr. Chabra was given the opportunity to respond, and the Trust's medical director wrote to Dr. Chabra saying that he proposed to deal with the conduct and capability issues separately, but that the breaches of confidentiality were potentially capable of amounting to gross misconduct in accordance with the Trust's disciplinary policy. So he proposed to refer the matter to a disciplinary panel, which, given the gravity of the allegations, would have had the option of dismissal as a sanction. Well, Dr. Chabra brought a grievance in relation to that proposed reference to the disciplinary panel, claiming that the conduct and capability issues should have been heard together at a capability hearing as provided for by the Trust's policy. But the grievance and a subsequent appeal weren't upheld, and so she consequently brought a claim to the High Court asking for an injunction to restrain the Trust from referring the case to the disciplinary panel, and she argued that her behaviour on the train shouldn't be classed as gross misconduct. Well, unbelievably, this case went all the way to the Court of Appeal, which said that the Trust was entitled to classify the doctor's behaviour as gross misconduct, given the fundamental importance placed by the health service on patients' privacy. But that's not the end of the matter. Dr. Chabra's appealed to the Supreme Court, and we're still awaiting a decision. So, the good news so far is that this case seems to confirm that in the vast majority of cases, employees who are facing disciplinary action won't be granted injunctions. But the case does also highlight how employees can find themselves being disciplined for breaches of confidences by working on their commute to work. And given that more and more employees appear to be using public transport as an extension of their office, you do need to have policies in place which cover this. And that's obviously particularly important where the work is of a sensitive nature. But, I mean, if you think about it, how many of you have used a laptop or made work-related phone calls on a train or a bus? Go on, hands up. Anyone prepared to admit it? Quite a few, actually. But you never know, actually, who else might be listening, or in this case, looking.
As you all know, an employer can attempt to protect its commercial interests by imposing covenants, which are aimed at restricting the activities of former employees in the months following their departure. However, the courts will only be prepared to enforce such covenants if they are reasonable and they're no wider than is necessary to protect those legitimate business interests. In CFF Holdings and Monday, the High Court held that a non-poaching covenant and a non-compete covenant contained in the company's employment contracts were unreasonably wide and so could not be enforced. The non-poaching covenant sought to prevent the solicitation of any employee. Now, this was a multinational company. The court found it was impossible to identify which of the company's numerous employees, both in the UK and overseas, were meant to be covered. The court also said that the non-compete covenant wasn't necessary to protect the company's interests. They would have been adequately protected by less intrusive means. The court was also influenced by the fact that not all the managers had restrictions in their contracts. This inconsistency undermined the argument that there were legitimate interests to protect. So it's a useful reminder that restrictive covenants are a restraint of trade, so they'll only be enforced if you make sure they're well drafted and justified.
We're going to deal with TUPE. To give it its full title, the Transfer of Undertakings, Protection of Employment Regulations 2006. But TUPE applies in two different, not necessarily mutually exclusive, situations, both of which are classed as relevant transfers. The first is a standard transfer, and that occurs where an economic entity changes hands and retains its identity post-transfer. And the obvious example there would be the sale of a business. The second is what's called a service provision change. And that usually arises in the context of contracting and covers most outsourcing, insourcing and retendering exercises. But it's important not to be caught out because where TUPE applies, there are what we might politely refer to as consequences. The employees move automatically to their new employer and they bring their existing terms and conditions with them. and if their terms don't match those of the other staff, you're not allowed to harmonise them unless you're bringing those terms up. What you can't do is reduce the terms down. There's also the obligation to consult, which we mentioned earlier, and compensation of up to 13 weeks' pay for every employee if you fail to consult workforce representatives. So you do need to be able to recognise when TUPE applies and when it doesn't. Which brings us on to two quite contrasting cases. TUPE only applies where there's an organised grouping of employees which has as its principal purpose the carrying out of the activities concerned on behalf of the client immediately before the transfer takes place. Somewhat perversely, though, an organised grouping can consist of a single person, but not always. So, in the Seawell case, we had a situation where an employee spent 100% of his time working on a single client's contract. Now, in that case, it was held that TUPE didn't apply. And the reason for that was that he was part of a larger group that worked on numerous contracts, and there was no evidence that the company had specifically made a deliberate decision to separate him out in order to just work for that one particular client.
By contrast, we've got the case of Rinder and Reinberger, where the EAT upheld a tribunal's decision that a single employee was an organised grouping of employees. Ms. Reinberger was employed to manage a portfolio of commercial properties in the Netherlands. She continued to manage the Dutch premises and was also given responsibility for a German portfolio of properties. But after a period of illness, it was agreed that she would stop managing the German portfolio and focus solely on the Dutch properties. She was the only member of staff engaged in managing the Dutch portfolio. Towards the end of 2010, it became clear that a British company, Rinder UK Limited, would assume responsibility for managing the properties in the Netherlands, and Ms. Reinberger began working for that company on the 1st of January 2011, continuing to manage the Dutch properties until she was dismissed later that year in the October. As she'd only worked for Rinder UK Limited for 10 months, she couldn't claim unfair dismissal unless she could claim continuous employment with her previous employer on the basis of a TUPE transfer. It wasn't obvious because she was the only person who'd moved to Rinder, and there had to be an organised grouping of employees. Well, the EAT said that she was. The work had been deliberately structured so that she worked exclusively on the Dutch portfolio. It was organised that way. The fact that she was the only one was irrelevant. But we might come back to you on this one in our monthly newsletter, because the case is on its way to the Court of Appeal and is scheduled to be heard any day now.
And for those of you that deal with TUPE reasonably regularly, you might be familiar with the term an ETO reason. And that stands for an economic, technical or organisational reason which entails changes in the workforce. Now, a dismissal will be automatically unfair if the sole or the principal reason for the dismissal is the TUPE transfer, subject to what is called this ETO defence. Now, case law establishes that an ETO reason has to entail changes in the workforce, and that only involves changes to job functions or numbers. Now, in the Miles case, Miss Miles was employed by BCB Limited to clean 6 coral betting shops and was paid £330 gross a week. She worked 7 days a week, but as long as she worked outside shop hours, it was up to her when she cleaned each shop and how long to spend doing the job. She held keys to all 6 shops. Now, in October 2009, Miss Miles was TUPE transferred to in situ cleaning along with a number of other cleaners. In 2010, in situ proposed a number of changes to their roles. Cleaning would be done within shop hours, and the cleaners would therefore cease to hold keys, although that wasn't actually going to apply to Miss Miles. Loan working would cease. New materials and equipment would be provided, and the cleaners would take on cleaning the shop windows, a job previously done by a third-party contractor. specialist contractor as they were referred to, but you and I'd know them as window cleaners. Now, these changes would have meant that Miss Miles worked a 30-hour week at fixed times and her income would have reduced by about half, and so she refused to agree to the changes and was dismissed. And she claimed that her dismissal was unfair. But the tribunal found that Miss Miles was dismissed for a reason connected with the transfer, but there were ETO reasons for the dismissal. There were economic reasons for the changes, so in other words, the desire to cut costs. There were technical reasons, new methods, equipment and materials. And there were also organisational reasons, so changes in working arrangements. There are also 2 changes in the functions of the workforce. The window cleaning, which was an additional duty, it was significantly different to the cleaner's other responsibilities, and the removal of the key holding responsibilities, which applied to all but Miss Miles. So there were ETO reasons, but did they involve changes in the workforce? I mean, after all, there weren't any redundancies proposed. Was there a change in functions? Well, the EAT has sent the case back to the tribunal to think again. The removal of the key holding responsibilities was a minor matter, and in the event it didn't actually apply to Miss Miles at all. So that really, if you think about it, left only one functional change, which was the taking on of window cleaning responsibilities. And the EAT hinted strongly that they doubted that this was enough of a functional change to fall as an ETO reason. So, what does all that mean in practice? Well, it means that the company wasn't entitled to introduce those new detrimental terms, and Miss Miles could almost certainly be able to claim that she was automatically unfairly dismissed as a consequence of the transfer.